My name is Lucy Rika. I'm the Executive Director of the Neukom Center for the Rule of Law. Welcome to the Rule of Law speaker series hosted by the Neukom Center. Today, we are honored to welcome retired Federal District Judge Mark Wolf. Judge Wolf served on the United States District Court for the District of Massachusetts for more than 40 years, including as Chief Judge from 2006 to 2012. Appointed by President Reagan in 1985, he assumed senior status in 2013 and stepped down from the bench in 2025. On stepping down, Judge Wolf published a widely read piece in The Atlantic titled, "Why I Am Leaving the Federal Bench," stating the reason for his resignation as, "I can no longer bear to be restrained by what judges can say publicly or do outside the courtroom. President Donald Trump is using the law for partisan purposes, targeting his adversaries while sparing his friends and donors from investigation, prosecution, and possible punishment. This is contrary to everything I have stood for in my more than 50 years in the Department of Justice and on the bench. The White House's assault on the rule of law is so deeply disturbing to me that I feel compelled to speak. Silence for me is now intolerable." We've asked Judge Wolf to speak about this decision and about his perspective on the independence of the judiciary and the DOJ at this moment in our country. Logistical message, when we get to Q&A, please come down to the microphone and line up, students, so that our friends on Zoom can hear your questions. Judge Wolf, welcome to Stanford Law School.
Good afternoon. You're all aspiring lawyers. I can teach you one thing. I don't know whether I can teach you anything else. But when you're in the courtroom and the judge comes in and says, "Good afternoon," the lawyers, with probably more enthusiasm they really feel, say, "Good afternoon, Your Honor. I'm no longer a judge, but you can make me feel very at home and as if I actually taught you something if we try this again. Good afternoon. You've got potential." I'd like to thank Lucy for that very kind introduction, even beyond quoting me. My father was alive, he would have liked it, and my mother was alive, she would have believed it. But it's a particular pleasure for me to be speaking here at the Neukom Center. As you heard, I worked for the Attorney General of the United States after Watergate from 1975 to 77. And I worked on many issues relating to how do you hold the highest officials in a democracy like the president accountable for criminal conduct. But I also represented the Attorney General in establishing the Vietnam, Laotian, and Cambodian refugee programs. And he asked me to go to the American Bar Association meeting in Montreal that year. It must have been in August, excuse me. And I spoke to the Young Lawyers Division, among others, about that program and what was necessary to resettle these refugees. And one of the leaders of the Young Lawyers Division was Bill Neukom. He went on to become president of the American Bar Association. There may very well be sitting in the room here today a future president of the American Bar Association. Last Thursday, I was in San Antonio at the request, the virtual insistence of the president of the American Bar Association, Michelle Benke, to talk to their board of governors, and at my request, also to leaders of the Young Lawyers Division and law students. And I thought that coming to the Neukom Center, named for a former president of the American Bar Association, it might be appropriate for me to give you essentially the same talk that I gave the Board of Governors last week. As to take a step back from my service as the Attorney General of the United States, in 1974, I'd graduated from law school in 1971. I'd been practicing law for 3 years in Washington, D.C. And I was watching with dismay the House Impeachment Committee proceedings concerning Richard Nixon and all that was coming out about evident illegal conduct emanating from the Oval Office, also from the Attorney General's office, and how lawyers were central to the crimes that comprised what came to be called Watergate, break-in of the Democratic National Committee headquarters for political purposes, but also illegal campaign contributions to President Nixon's reelection campaign. And I got a call kind of out of the blue. I'd been seeking a position in the Nixon administration. I was never offered a job that appealed to me. And I was offered an opportunity to interview and then to work as a special assistant to the new Deputy Attorney General, Lawrence Silberman, who had been the Undersecretary of the Department of Labor and fired after the 1972 election because he refused to let the Labor Department be used for partisan purposes in the election. But he did get installed as the Deputy Attorney General. And I became his special assistant while Richard Nixon was still the president. All the lawyers I worked with and other people who cared for me urged me not to go to the Department of Justice. They said, you will be stigmatized professionally for life by being associated with this disreputable administration of the Department of Justice. And it was disreputable. Attorney General John Mitchell, who was also Nixon's campaign manager, eventually went to prison for the crimes connection with the break-in at the Watergate complex, and also for lying to Congress about it. And his successor, Richard Kleindienst, is also convicted of lying to Congress, but didn't go to prison for that. But being 27 years old, I think at the time, 27 years old at the time, I thought they really needed more honest lawyers in the Justice Department. So I would go and straighten out the president. Modest aspiration. And I started in May of 1974. And in June of 1974, Supreme Court ordered Richard Nixon to turn over the tapes that he had been secretly making in the Oval Office that had substantial evidence of criminal activity by him and his closest colleagues. And at that time, the president could have refused to obey the Supreme Court order. He could have destroyed the tapes. But he didn't, because he knew the American people would not tolerate disobedience of the Supreme Court order, particularly by the President of the United States. And if he did that, he would certainly be impeached by the House of Representatives and removed from office by the Senate. And therefore, he gave the tapes over to the Watergate special prosecutor and his grand jury, and he resigned. As a result of that, I was there when President Gerald Ford nominated Edward Levy, the president of the University of Chicago, to become the Attorney General. And I had the opportunity to organize Edward Levy's swearing-in ceremony at the Department of Justice, and then to become one of his 4 and then 5 special assistants, lawyers, all 28, 29 years old, for the next 2 years. I worked on issues of how do you hold the highest officials accountable in a democracy for criminal conduct, among other things. And when Jimmy Carter won the election, presidential election in 1976, I returned to Boston, where I grew up, in the hope of becoming essentially a public citizen in that community, and to render public service in a range of potential ways. In 1981, I became the Deputy United States Attorney, District of Massachusetts, and the chief of the Public Corruption Unit in that office. And at that time, corruption had been found to be a way of life in public contracting, and there was accurately perceived to be, we demonstrated a culture of corruption in the city of Boston. Virtually possible to build a building in the city of Boston in that period without paying a bribe, and a big one. And after my public corruption unit won more than 40 consecutive cases, including a dozen convictions of the powerful mayor of the city of Boston, Kevin White, I was appointed a United States District Judge. I was 37 years old when I was nominated. I was 38 years old when I was confirmed and took office. At that time, I was one of the youngest of the 750 federal judges in the United States. And it was a great honor and opportunity for me to continue to work, to give integrity to our nation's ideal of equal justice under law, something that Attorney General Levy particularly modeled, and something that I was striving to emulate in the U.S. Attorney's Office. And I was honored to have the opportunity to do that for life. As you know, it's a lifetime appointment. I became a senior judge 14 years ago after my term as chief judge ended. So I've essentially been working for no pay for the last, I've been working for no pay for the last 14 years. I was entitled to retire and get my salary for life when I was 65. But the opportunity to do something that's important to people every day, that was always the most gratifying part of being the United States District Judge, was very appealing to me. And I thought I would do it as long as I was capable of doing it. But to my surprise, on November 7th of last year, I resigned. And I resigned to join others, as you heard Lucy say, to combat what I regard as an existential threat to the rule of law and democracy in the United States at this moment in our history. Because as I said, I'd been dedicated to giving integrity to this ideal of equal justice under law. After President Nixon resigned, Gerald Ford, who was the vice president, but not the elected vice president, he became vice president when the vice president, Spiro Agnew, pled guilty to taking bribes as governor of Maryland and when he was vice president. So Gerald Ford, Speaker of the House Representatives, became the vice president. Nixon resigns. All of a sudden, he's the president of the United States. And the Department of Justice, as I said, was in disrepute. So he asked Edward Levy to become the Attorney General. Edward Levy was the president of the University of Chicago. He had a richly deserved reputation for intelligence, for integrity, for impartiality. And the president told Edward Levy, I want you to be an Attorney General who will look out for the interests, protect the interests of the American people if they're ever in conflict with what you perceive to be the president's interests. At his induction ceremony, Edward Levy said that nothing can more weaken the quality of life or more imperil the realization of goals we all hold dear than our failure to make clear by word and deed that our law is not an instrument for partisan purposes. And I saw Attorney General Levy do that over the next 2 years. And it's something that, as I said earlier, I strived also to do when I was the Deputy United States Attorney in Boston. And I strive to do that as a judge, as an impartial judge. You're an impartial judge, you're going to take an oath to be impartial. You're going to make decisions at times that don't sympathize or don't fit with your personal sympathies, but they're the legally correct decisions. And I had a reverence, I still have a reverence for the Department of Justice. It's functioning properly. But in 1998, well, in 1997, I was the first judge apparently in the country who ever ordered the FBI to disclose whether someone was one of their top echelon mafia informants. There were actually several of them, but primarily James Whitey Bulger and Stevie the Rifleman Flemmy. And I conducted 9 months of hearings in 1998. 1999, I wrote a 661-page decision about the criminal conduct and misconduct of certain FBI agents in connection with Bulger and Flemmy, who were notorious murderers. In exchange for information concerning the mafia, I found that the FBI didn't investigate them, told them when other agencies were investigating them, told them when there were wiretaps targeting them, told them about people informing on them who then died or disappeared, and told them that they were about to be indicted and they should flee. Bulger left, Flemmy didn't leave early enough. And Bulger was gone until 2011 when the FBI really wasn't looking for him. And it was very disturbing to me. These crimes occurred because guidelines for informants that Attorney General Levy had developed were eventually admittedly ignored, would have prevented these abuses. The FBI handler was sentenced to 10 years in prison for attempting to obstruct my hearings and another 40 years in prison in Florida for a conspiracy to commit murder, which I initially found he did. Of course, this caused me great disappointment in the Department of Justice, but it was the legally correct thing to do. As I said, Attorney General Levy rightly said, there's nothing really more dangerous than the use of the power to prosecute for partisan purposes. The present administration we have of the Department of Justice is the opposite of Attorney General Levy. And there's a difference between politics and partisanship in the administration of justice. I published a Boston Globe opinion piece about this in 1992. To me, politics is democracy. Law enforcement issues are frequently prominent in campaigns, or issues relating to the Department of Justice, like immigration, as we've just seen. If the president gets elected, he's entitled to reorder the priorities of the Department of Justice. They were going to devote more resources to immigration, fewer to civil rights. People don't like that, elect somebody else in the next election. But once those policies are set, decisions, particularly whether to prosecute, cannot be made because somebody's your friend or your enemy. It has to be made pursuant to standard procedure, established procedures, without fear or favor. And that's not what's happening now. President instructs the Attorney General to prosecute his purported perceived political enemies, and also to protect his friends, his colleagues, and people who enrich him and his family or donate to advance his political prospects. This is exemplified by the contrast between the way that former FBI Director James Comey has been treated and the way the President Immigration Czar, Border Czar, Tom Homan has been dealt with. The Department of Justice has principles of federal prosecution. They're in the U.S. Attorney's Manual. They're also in regulations. But the principles of federal prosecution say that Department of Justice prosecutors should not seek an indictment of anybody unless they believe they have sufficient admissible evidence to probably prove that case beyond reasonable doubt. That's part of the reason we had such a good record for so long. When I was a prosecutor, I took that seriously. There were people I was confident were guilty, but I didn't feel we had enough admissible evidence to prove it. Sometimes we got it later, sometimes we never got it. But that principle is important because, and this is in the Department of Justice manual. First of all, it's very inefficient to have a case and have the judge throw it out because there's not enough evidence, so Rule 29, or to have a jury find the defendant not guilty. But more importantly, it's spelled out there. The mere fact of getting prosecuted is punishing. It's costly. It is emotionally taxing. It's injurious to one's reputation. But Comey and Tisha James were prosecuted because the president felt they were enemies and instructed the Attorney General in a tweet to prosecute them. And many prosecutors, you know this, resigned or were forced out of office because they refused to try to initiate those indictments. Eventually, they put somebody in there who was willing to do that, and the indictments were dismissed by judges. And in other cases, in the James case, I think particularly, grand juries, which rarely fail to indict if a prosecutor presents the case, refuse to indict. In contrast, reportedly, it was an undercover operation focusing on immigration enforcement, and Tom Homan's name kept coming up. So that undercover operation where the FBI created a fake company and a fake executive of that company, and they met with Homan in September 2024, 2 months before the election, reportedly, and gave him a bag of cash with $50,000 in it. And I expect that if and when we ever see that video, hear those tapes, it'll be quite explicit that this was a down payment as a bribe for him to use his influence if Trump got elected and he got the kind of authority over immigration detention facilities that would have to be built, things like that. And he took the money for it. And when Trump got elected, the spokesperson for the president said this case has been closed because there was no credible evidence of any criminal activity. Didn't say no evidence. And Homan first said, I didn't do anything criminal. About a week later, he said, I never took the money. But this I think, is really totally out of the ordinary, irregular. Normally, if you would have an undercover operation, somebody before he took office took $50,000 in a paper bag, a kava paper bag. Once he was in office, you would go back to that person, probably a bigger bag of cash, and try to develop and record even more evidence and have a clearer case because now the person's in office. And I think that the Congress and the American people should know. I know there's principled and certainly political reasons for to be a lot of interest in the Homan, in the Epstein tapes, Epstein files. But I think there should be much more with regard to the Homan matter. And in fact, as a lawyer, I'm working with others in a pair of ways and putting some people together to try to get Congress and through Freedom of Information Act requests, people this evidence would show maybe Mr. Homan didn't take cash and his reputation shouldn't be tarnished by these suspicions. But maybe it will show that he took a bribe, and this man who's interested in getting all these criminals out of the United States and leading edge of some very cruel efforts aimed at aliens, may be a criminal himself and be given a free pass because they wanted him in the Trump administration. So right now, I resign, and I am a senior counsel of a 50-person law firm in Boston, Todd and Weld. It's a firm that attracted me. It's the only one I could think of I might ever join. One of its leaders is the lawyer I appointed to represent Whitey Bulger when they found him in 2011. But he only had the assignment for a week because the government dismissed my case, which was fatally flawed. Decided they'd like to try again with another judge, and Bulger was eventually convicted of murder, died in prison. But it's 50 lawyers. If you go on the website of Todd and Weld, you see they prominently advertise their commitment to diversity, equity, and inclusion. And it's a firm that just didn't want to just give me a place to go every day, but wanted to partner with me in my public advocacy. And they're doing that. In fact, put together a team for one matter. I won't mention what it is. The week between Christmas and New Year's, and had two partners, an associate. And after our first organizational meeting, the most senior of those partners said to me, "Thank you." And I said, "What are you thanking me for?" Because I'm worried I'm going to be at the firm and impoverish them with all this pro bono work. He says, "We're all sitting here wondering, what can I do? What can we do? Now you've given us something to do. Got a case, got a matter." And the offices of Todd and Weld are down the street from the old State House, going back to Revolutionary times. And it was the site of the Boston, what's called the Boston Massacre. 1770, was a brigade or a number of British troops outside the State House. They were being pelted with ice and clubs by Americans. The people who were protesting their presence and attacking them were shot and killed, many of them. And John Adams at that time was a 35-year-old lawyer. He had just moved from Quincy outside of Massachusetts to Boston. He was trying to develop a fledgling law practice, and he was asked to represent the captain who was the head of this group of soldiers, Captain Preston, and all the soldiers. And certainly foreseeably foreseen, imperiled his desire to develop a practice, support his family. But he did it. And he got them all acquitted. And the American people didn't punish John Adams for that. In 1796, they elected him the second president of the United States. In 1779, Adams was the primary architect of the Massachusetts Constitution. And he enshrined in that Constitution the words that the Constitution would establish a government of laws, not men, meaning a democracy. And he knew from experience, though, that to have a government of laws, not men and women, you need zealous, fearless lawyers to make that democracy a reality. The United States now has a president who is not in the tradition of John Adams. He's in the tradition of Shakespeare's Jake the Butcher in Henry IV, Part 2. In Henry IV, Part 2, a coup is being planned. And Jake the Butcher says, and people now think, this is a joke. You put it on a coffee cup, you put it on a t-shirt. It's not a joke. So Jake the Butcher says, the first thing we do is kill all the lawyers. Probably seen it. Because it's known that lawyers are essential to the enforcement of the laws, the rule of law. And in our era, lawyers are essential to the rule of law, where the law in many ways is intended to protect the people. In the Declaration of Independence, it was declared, and Adams, along with Jefferson, was a primary author of the Declaration of Independence, that people are endowed with certain inalienable rights. Among these are life, liberty, and the pursuit of happiness. And governments are established, given their just powers with the consent of the governed, to protect those inalienable rights. In the Constitution, all this starts, we the people. And that means that all power is in the people. Some of it is delegated by the people to the states, some to Congress, some to the president. And it's the role of the courts to hold those elected representatives to the limits of the power that the people have given them. And the only way courts can do that is in actual cases and controversies brought by lawyers. A lot of people now recognize how important the courts are as a pillar of democracy. But Jeremy Bentham said, the law is not made by the judge alone, the law is made by the judge and company. The law is made by judges and lawyers. And we now need lawyers in John Adams' tradition. And we may not have enough of them. Every year, the International Bar Association Human Rights Institute, on January 24th, publishes a report on the endangered lawyer in a particular country. In recent years, they featured Afghanistan, Turkey, Iran, the Philippines, and Belarus. In 2026, just a couple of weeks ago, this year's report focused on the endangered lawyers in the United States. And not because we're worse than all of these other countries. We're not there yet. And I hope we'll never get there. But because the United States for so long has been an inspiring model of what a citizen can do, what a court can do, a judge can do, and what a lawyer can do. And I know people around the world who've shown great courage and suffered severe consequences, imprisonment in Turkey, judges exile from Russia, young lawyers, people I'm very close to, because they wanted to make their countries more like this country. And now the United States is losing that status as a model. President Trump explicitly threatened certain big law firms that had previously represented parties and interests adverse to his. And some of those firms capitulated. They agreed to stop providing that representation, and they agreed to give hundreds of millions of dollars in services, pro bono services, to advance Trump's agenda. And there are other firms that engaged in what Timothy Snyder, in his stunningly prescient and helpful book on tyranny back in about 2018, called anticipatory obedience, doing things in advance that they think Trump wants big law firms to do, so he wouldn't focus on them. And as Snyder points out, that this kind of anticipatory obedience is something that facilitated the very rapid early progress of Hitler before World War II. Fortunately, we still have big firms, some big firms that stand out. Wilmer Hale is in Boston. It's right across the street from the old State House, the site of the Boston Massacre. It has a proud history. If you watch, as I did on the plane, the Netflix version of the play with Edward R. Murrow, played by George Clooney, Good Night and Good Luck, you see Joseph Welch of Hale and Dora, was then called, standing up to Joseph McCarthy in the McCarthy Army hearings of the early 1950s, and essentially bringing McCarthy down after he had terrorized almost everybody in the country by claiming so many people were communists. And former managing partner of Wilmer Hale is my friend Bill Lee. He is also essentially the chairman of the board of Harvard. And he told me that when they were deciding whether to capitulate to Trump or stand up, he said to his colleagues, "What are we going to tell our grandchildren? What did we do at this crucial period?" And they've stood up. But it's mainly smaller firms like Todd and Weld that have been working with my friend, former Ambassador Norman Eisen's Democracy Defenders and others, suing Trump around the country. These smaller firms don't have the same level of resources that the bigger firms do. So what can lawyers do about this? What could the American Bar Association do about it? I said, well, one thing they could do is urge these large firms to stand up and do what's in the finest tradition of lawyers in this country, and assure that clients that desperately need representation have it. It was recently reported by the Washington Post that between January and September 2025, the big law firms in this country represented plaintiffs challenging Trump executive orders 15% of the cases, meaning in 85% of the cases, the lawsuits were brought by smaller firms. And what could you as law students do about this? Reportedly, students and young lawyers are already doing it. You know, you'll have choices about where to go to work. And you want to go someplace where you'll be working for good role models. And firms that capitulated are probably not going to provide those models for you. One of my former clerks recently left the first firm to prominently capitulate and went with some of the partners in that firm to a new one. Another thing that I think is important for lawyers to do is educate the public to the importance of insisting that the president obey court orders. Judges can only speak in hearings in their courtroom and in their written decisions. But when my former colleagues now rule against the president, he instantly, he's got the ultimate bully pulpit. Some people say the bully's pulpit. He's the president of the United States. He can send out a tweet or whatever it's now called, and he says, you know, these judges are crooks, like the criminals, like the judges who presided in the cases against me, and they should be impeached. And I was elected president. They weren't elected. They don't have any right to do this. When, of course, what the judges are doing, or what judges are supposed to do, hold the president to the limits of his power, delegated from the people. But if the American people don't have faith in the integrity, impartiality of judicial decisions, and cause the present president, to feel like Donald Trump, like Richard Nixon, that they have to obey a court order, otherwise they'll be removed from office, then there's no limit on what the president can do. Then you don't have a democracy. You have a tyranny. And 2 weeks ago in Minneapolis, a federal judge was actually a federal judge who I believe had clerked for Justice Scalia, found that ICE had violated 90 of his orders in 76 cases involving the detention of aliens. And he said, this is more than most agencies have ever disobeyed in the history of their existence. But that's going on. And you can get out and talk to people about the importance of supporting the courts and judges. And also, I think it's very important to develop some bedrock principles that are shared by all lawyers and hopefully all Americans. There can be Democrats, it can be Republicans, it can be disagreement on particular issues. So we should all, I think, have the attitude that Abraham Lincoln had from litigating innumerable cases, most of them small before he became president, that you can have adversaries who aren't your enemies. You know, if somebody's your adversary in court, you know, you want to defeat them with the power of your arguments, the merits of your case. You have enemies, you want to destroy them. And I think the rhetoric's very important. But Lincoln, second inaugural address, really remarkable. After almost toward the end of this bloody civil war, that we're going to proceed with malice toward none, charity for all. Contrast that to the president now. There's an organization called the Article 3 Coalition, made up of former judges that I've been invited to join. And they published a proposal in the New York Times, January 19th, saying that the American Bar Association should revise its model code of ethics to embed certain democratic principles in it. The principles, which we've posted in full online, call on lawyers and their organizations to reinforce the most basic professional commitments. That starts with something that the federal courts have already affirmed: representing clients, donating to causes they support, and expressing beliefs regarding the value of equal opportunity are activities protected by the First Amendment. We have a right to pursue them free from government coercion or retaliation. Beyond that, the principles declare that lawyers and their organizations have a duty to challenge government actions when their clients' interests require it. We have a duty to help individuals or groups that can't afford counsel. And donating our services to wealthy and powerful clients does not count. We must promote confidence in the integrity of the legal process through all our actions, including being both truthful and candid. We must refuse demands that would require us to violate these obligations. So hopefully the American Bar Association and young lawyers who heard me speak and said they would urge the ABA to do that would be great. I also I'm trying to promote more interaction between senior lawyers and younger lawyers and law students. People understand that it's valuable to have senior mentors. I don't think many of them understand the value that younger people have to their elders and crushing their idealism, usually holding them to high standards and giving hope for the future. And I have legions of devoted law clerks, and 3 of them have their own initiatives to promote democracy. And now they're working with me, but I'm working with them on their initiatives because it's young people who are figuring out how to do things that people my age think are impossible. And I think we need to talk to people who are not inclined to agree with us. I don't know if any of you are in the Federalist Society. I'm going to be meeting with you. Some show up after this talk because I don't want them just to hear me. I want to listen to them. I don't think anybody's got a monopoly on wisdom. When I resigned, I was telling people close to me that I was taking a leap into the unknown. The only thing I knew was that I would be working with admirable others in a crucial common cause. And I hope that some, or indeed all of you, will join that common cause in whatever way you can. I concluded my Atlantic piece saying, I resigned in order to speak out, support litigation, and work with other individuals and organizations dedicated to protecting the rule of law and American democracy. I also intend to advocate for the judges who cannot speak publicly for themselves. I cannot be confident that I will make a difference. I'm reminded, however, of what Senator Robert F. Kennedy said in 1966 about ending apartheid in South Africa. Each time a man stands up for an ideal, or acts to improve the lot of others, or strikes out against injustice, he sends forth a tiny ripple of hope. And I added, enough of those ripples can become a tidal wave. And I wrote, and as Nobel laureate Seamus Heaney wrote, sometimes the longed-for tidal wave of justice can rise up, and hope and history rhyme. I want to do this, I wrote. I want to do all I can to make this such a time. And I hope you will too. If you do, if you join this crucial cause, you'll make it possible for it to continue to be said what Justice Robert Jackson said in a speech that came to be known as the county seat lawyer in 1950. Might have most recently seen Justice Jackson in the movie Nuremberg. He was the chief U.S. prosecutor of the Nuremberg trials. Actually, he helped conceive them, made a significant contribution in conceiving the Nuremberg tribunal. He grew up in Jamestown, New York. He never went to law school. He became, among other things, Attorney General of the United States. He was on the Supreme Court. And he wrote this about the county seat lawyer. He said, the law to him was like a religion, and the practice of it was more than a means of support. It was a mission. He was not always popular in his community, but he was respected. Unpopular minorities and individuals often found in him their only mediator and advocate. He was too independent to court the populace. He thought of himself as a leader and lawgiver, not a mouthpiece. He lived well, worked hard, and died poor. Often his name was in a generation or two forgotten. It was from this brotherhood that America has drawn its statesmen and its judges. A free and self-governing republic stands as a monument for the little known and unremembered, as well as for the famous men of our profession. As I said, I hope you'll contribute to making it possible to continue to say that about our country. Thank you very much.
For a few questions, does anybody have any? I can start with one. One of the things I'm curious about, Judge, from your long experience is what do you think specifically might be done to address the partisan nature of judicial appointments these days?
Well, I think that if the Senate would play its proper role, scrutinize whether this is always a political process. Again, there's a difference between politics and partisanship. The scrutinized people. The president nominated Emile Beauvais to go on the Third Circuit. Beauvais reportedly told my former law clerk, Erez Ravini, don't be candid with the judge in this immigration case, Abrego Garcia. We don't have to obey court orders. Senate Judiciary Committee wouldn't let Erez testify to that. He's got a whistleblower complaint. And the Senate quickly confirmed Beauvais. He's now on the Third Circuit. He was there a couple of weeks, and he went to a political event at which Trump was speaking, which is a violation of the Code of Conduct for judges below the Supreme Court. So I think that's really that advise and consent procedure, if it was properly applied, it would deter the president from nominating people who have a record that suggests that they won't be honest, impartial judges. Second question? That's unusual. All right, here we go.
Thank you so much, Judge Wolf. I'm curious what your thoughts are on the current discourse, especially coming from Justice Roberts and other members of the Supreme Court, about how the public can correctly critique the judiciary. This is sort of a big issue, I feel like, even in talks at the school, where there are lots of people trying to draw boundaries about what's appropriate criticism versus what's not appropriate criticism when you disagree with process or substance of a decision.
Well, to me, unfortunately, when the president says all judges are crooks, they're ruling against me, then there are death threats against judges, and they're swatting and delivery of pizzas in the name of the son of the murdered son of a judge in New Jersey. But I think almost any criticism of the courts that's short of a threat is permissible under the First Amendment. And as long as there's an equal or somewhat equal opportunity to be heard, we should rely on the marketplace of ideas. The problem now is such a disproportion in the ability of different people to be heard. The president can be heard anytime he wants, loudly, and other people get drowned out. very wealthy people in political campaigns can be heard. They give one way or another virtually unlimited amounts of money, and the rest of us may be willing to speak up, but we get drowned out. So I think this is a big First Amendment issue. But essentially, other than threats, I think anything can be said, and hopefully there can be a response that's heard and that will prove to be persuasive to a large number of.
Hi, Judge Wolf. Thank you for the presentation. There was one thing that you said, which I've been thinking about, which is, talk to each other. Because I feel like that's advice that I've heard from lawyers and non-lawyers alike, talking about decreasing polarization and I guess, roughly speaking, existing as one body politic. During my time at law school, I feel like I've figured out that, and as an aspiring litigator, I think I've realized that lawyers do a lot of talking at each other rather than talking to each other. And I feel like when it comes to things like the rule of law, there's also this, kind of absolute sense of this must be preserved, this uncompromising sense. And I'm curious, since we're living in an era where we have a lot of polarization and where the polarization doesn't necessarily seem to be predicated on substantive policy issues, but more or less the framework of how we conduct things, I'm kind of curious, where do you think that balance lies between the very lawyerly, there is no compromise, we must simply, protect these things versus, there has to be some leeway. Otherwise, this country isn't going to be able to coexist together with the same kind of premises.
Well, I think that there can certainly be policy disagreements. You can disagree whether immigration should have the same priority that it has. And you can possibly disagree with certain tactics that are used in immigration enforcement. But there ought to be certain bedrock things, like everybody's got freedom of speech. Everybody's entitled to a lawyer. Everybody's entitled to due process if their liberty is at stake. And I mean, that's where I draw the line. And that's what this Article 3 coalition is trying to get advocating be embedded in the code of ethics for lawyers, because we shouldn't have a one-party country, I don't think, no matter what party it is, and no matter when it is. That's a check and balance, political competition. But there should be certain bedrock principles, certainly accepted by all lawyers and advocated by all lawyers. Otherwise, we don't live in a democracy, and we'll suffer from it.
Thank you very much. Let me echo everyone's thanks, not only for the piece, but for coming today. A brief question, and maybe you can disabuse me of my cynicism, but you've mentioned sort of the mechanisms that might be brought to bear to encourage, for example, big law to fix some of this 85% disparity. I think the pessimistic read is that the moral appeal has not yet worked. And it doesn't appeal really that the business pressures have been such to shift the calculus. So I'm wondering sort of if your conversations either with the ABA or with colleagues suggest to you that there are specific mechanisms that law students or others can take that would in fact apply pressure in the right way to shift that calculus.
Well, to a certain extent, as it's sometimes said, you could vote with your feet. All these law firms want the best students and the best young lawyers. And I know that a good number of them are being trained right here. So, tell them, thank you for your interest in me. I'm not coming because you capitulated to Trump. And you'll have another good opportunity. And probably a place you'll feel much more comfortable. You can support because I was asked to talk to the Board of Governors. I said, I also want to talk to the Young Lawyers Division. And the leaders of that division were invited to my talk. And afterwards they said, oh yeah, this is good. We'll work within the ABA to try to get these, to be basic incorporated duties of lawyers. Assure everybody has representation and don't permit coercion or retaliation. if you're representing an unpopular party. And I think, that, older lawyers, they have habits. For me, I've been extraordinarily fortunate. The law has been a calling. In my professional lifetime, it became a profession, but it's a profession that had ideals and principles. Now, to many lawyers and law firms, it's become a business. And getting it back to at least a profession and looking for opportunities to make it a fulfilling calling is something you can work on.
May I abuse the privilege and just ask very briefly, do you see a role for the judiciary informally in this? In other words, are there conversations being had behind closed doors to encourage managing partners that perhaps their arguments will be viewed with a little bit less charity?
Not to my knowledge. And in fact, there wouldn't be. You can't, the judges have to decide cases impartially based on the facts, based on the evidence, based on the law. And sometimes judges can give out what might be regarded as honors, opportunity to do this or that. It was up to me. I wouldn't give them to people in these firms that had capitulated. But basically, this is not where judges, I think, can take the leading role.